It's called the SAFE Act, and it became law just 1 month after children and adults were gunned down inside of a Connecticut elementary school. And a provision of the law limits the amount of bullets someone can have in a clip.
The way it was written, you could not have more than 7 bullets in a semi-automatic handgun. Soon after that law was passed, somebody was arrested and someone challenged the law, and they challenged it in federal court out in the Buffalo area.
The court said the number 7 was, quote, arbitrary, leading to confusion on how it should be enforced.
It becomes very problematic for us because, you know, if you're outlawing the large capacity magazine, which many of us, including myself, believe was the intent of the law, to get rid of these 30 or 40 round magazine clips that you can put in you know, your assault type of rifles and knock it down so you only can have 10, then make the law what the manufacturers make. 7 does not make sense, and I'll tell you why it doesn't make sense. Because no manufacturer of handguns produces a magazine that holds 7 bullets. Its maximum capacity is 7.
McNamara says the uncertainty of the law has prompted district attorneys to not prosecute those cases, including himself.
If somebody has 10 rounds in their magazine, they're not getting prosecuted in this county. It's just not going to happen.
The 2013 law also said an assault rifle had to be registered. Historically, that wasn't the case.
It was a little bit complicated when you're talking about assault rifles because they grandfathered them in, so people that had one before the law was passed could keep it. And there was a lot of registration issues with the SAFE Act that were very problematic, and as the date of implementation arrived, there was no database created, or at least it was created, but the data entry was so far behind that none of us could really rely upon it. So none of us have prosecuted any of that.
In Utica, Ben Dennis, Eyewitness News.